Good evening. Welcome to Santa Clara County Planning Commission. This is a call to order for the August 27th, 2026 Santa Clara County Planning Commission meeting. Will the clerk please call the roll?
Commissioner Rouser,
Present.
Commissioner Asabi,
Present.
Commissioner Levy,
Here.
Vice Chairperson Hederle,
Here.
Commissioner Belska,
Here.
Commissioner Brio is absent, Chairperson Cohen,
Present.
you have a quorum.
Thank you. Please stand if you're able for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Good evening. I'm Jean Cohen. I'm the chair of the Planning Commission. And on behalf of the commission, welcome to tonight's meeting. At this time, we'd like to remind you to please turn off your cell phones or any other electronic devices so there's no meeting disruptions. And the first item of the agenda is public comment.
We have not received any requests to speak.
Okay. There's nobody here to speak for public comment, so we'll move on to agenda item number 4, the consent calendar. I believe there's 2 items on the consent calendar, the May and June minutes. Is it appropriate to ask for a motion? Yeah, is there a motion or discussion?
I'll make a motion we approve the consent calendar.
I'll second.
There's a motion and a second to approve the consent calendar. We'll vote on that motion.
Commissioner Rouser,
I approve.
Commissioner Hasabi,
I approve.
Commissioner Levy,
Yes.
Vice Chairperson Hederle,
Yes.
Commissioner Belska,
Abstain.
and Chairperson Cohen.
Yes.
With 5 yeses and 1 abstention, that passes.
Thank you. I believe we'll now move on to the regular part of the agenda, but there might be an update from one of the commissioners on item 6. Yes, got it. The first item on the agenda is item number 5, a public hearing to consider a concurrent land use application consisting of a renewal of a use permit with architectural and site approval for the continued operation of the Waldorf School of the Peninsula. That item has been held, and so if you're here to speak on that item, we'd like to ask the staff to either give more information about when we might hear that again or any other instruction.
My name is David Horowitz. I'm an associate planner with the department. I can speak on that.
Thank you.
Item 5 before you is county file number PLN 25-034, which is the use permit renewal for the Waldorf School. The applicant, the Waldorf School, communicated to planning staff that they would like to continue the item to a date uncertain so that they can review their project scope. Following county review of any change to the scope, the project would be re-noticed and brought back before the Planning Commission to render a decision. Planning staff supports the continuance of this item to a date uncertain and is available to answer any additional questions the commission may have.
Thank you. Are there any questions of staff from the commissioners? There aren't any questions. Do we need to vote on the postponement? Okay. Thank you very much.
Through the chair, we do have 1 hand raised for public comment.
Okay, we'll take that.
And we have no others in the room, so just 1, sorry, now 2 in Zoom. Okay, we seem to be holding at 2. How much time did you?
2 minutes each.
2 minutes. Your timer will begin when you start speaking. Our first speaker is Lika S. Please accept the unmute. Lika S., you can begin speaking when you're ready. Okay, we'll circle back. We can move on to our next speaker, Rahman Kapoor. The timer will begin when you start speaking. Please accept the unmute.
Hi, this is Rahman Kapoor. Can you hear me?
Yes.
So my name is Rahman Kapoor. I live very close to the school, just on the cul-de-sac next to the school. And I have looked at the study, the traffic study that has been done. And the point I want to make is while the study shows that the amount of traffic it creates is the roads are adequate to handle it, the reality is the parents park on the street, and because there's not enough, they all come down on on Eastbrook, sorry. After they take 280, they come down on Eastbrook, and they park on Eastbrook, and then they take a U-turn. And there is a very small space in there which they do this. And I'm sure it is a traffic hazard and also a dangerous situation. The school has provided for red flags on each of the corners which the kids carry from one side to another. Because I'm sure there have been occasions where it's been a safety issue. And the more traffic we allow in this particular area, which is a very narrow 2-lane space, it is just not designed to handle so many kids come in and all at once, and kids and parents who are coming from a much wider area, and they don't go into the school to park and drop the kids. They're in a hurry, they come in, they take a U-turn, and invariably it's just, and then you have kids walking around all over the place. So I just wanted to make that point.
And trying again for Lika S. If you could accept the unmute, the timer will begin when you start speaking. My apologies, Lika, but it does not seem that we are able to hear you. You can feel free to email us or submit written comment, and we will have to move on. Chair.
Is that the final speaker for that item?
That is the
Move on
final
to-
speaker.
Okay, thank you. So I believe we're moving on to agenda item 6. I will read the item, and then we'll hear from,
Chairperson
Yes.
Cohen?
yes.
In abundance of caution, given my employment with Valley Water and because my work at Valley Water may intersect with the requirement that this project obtain approval from Valley Water for aspects of its stormwater drainage system, I am electing to recuse myself from this matter, even though I do not have a disqualifying conflict of interest under applicable law. So I will leave the room for this item.
Thank you very much. This is a public hearing to consider a concurrent land use application consisting of a major subdivision and grading approval to subdivide an approximately .96 acre lot into 7 lots ranging from 3,718 square feet to 4,490 square feet, with 1 single-family residence on each lot, including 1 residence reserved for a low-income household earning up to 80% of the area median income. This is a CEQA exempt pursuant to the Public Resources Code. The applicant is Kurt Anderson. And do we have a report from the staff?
Yes.
I think it's to open the public hearing right now, or do we hear the staff report first?
Staff report would be first.
Okay, we'll hear from the staff first, and then we'll take any questions from the commissioners and public comment after.
Good evening, Chair Cohen and members of the Planning Commission. Please allow me one moment to share my screen. My name is Parya Saif, project planner for item number 6 on the agenda. The project before you is a request for concurrent land use application for a major subdivision and grading approval for a 7-unit single-family residential housing development at 379 Meadow Lane, San Jose. The project site is located within an unincorporated pocket of the city of San Jose, approximately 250 feet west of the intersection of Jerry Lynn Drive and Meadow Lane. The property is within the urban service area of the city of San Jose and doesn't have a county general plan designation, and it is zone R1. The lot is 0.96 acre in size, and it has an average slope of less than 10%. The existing and proposed use classification of the site is single-family residence, and the surrounding properties to the north, west, and east are also primarily developed with low-density single-family residences. The southern portion of the property is bordered by Valley Water easement containing North Babb Creek, which is a channeled creek approximately 33 feet from the property line. The site is currently developed with one single-family residence and associated accessory structures, which are all proposed for demolition. The site has a direct frontage along Meadow Lane, which is a county-maintained road providing access to the property. The site is relatively flat and doesn't contain significant topographic constraints that would preclude development. The site contains 27 trees, all proposed for removal, of which none is considered protected tree pursuant to the County Ordinance Code Division C16 and Guideline for Tree Protection and Preservation for Land Use Application, as trees in R1 zone are not considered protected trees, and none of the trees proposed for removal are California native trees. No streams or riparian corridors are located on the site. The site is located within the Santa Clara Valley Habitat Plan area. However, the project is not covered under the Santa Clara Valley Habitat Plan, as no Habitat Plan covered plant or wildlife species nor any sensitive land covers are present on the site. The lot is currently served by the County Sanitation District number 2 and 3 for sewer connection and by San Jose Water Company for portable and fire protection water supply. The proposed project was submitted under SB 330, commonly referred to as the Builder's Remedy, and is subject to the provisions of the Housing Crisis Act of 2019 and the Housing Accountability Act. The project includes subdivision of an approximately 0.96 acre lot into 7 lots ranging from 3,718 square feet to 4,490 square feet, and construction of one single-family residence on each lot, including one residence reserved for low-income households. Access to the proposed lot will be provided by a private street off Meadow Lane and 2 fire truck turnarounds, all dedicated to public use. All 27 trees on the site are proposed to be removed, and as it was explained in the previous slide, none are considered protected trees, and as such, replacement trees are not required. However, the project proposes planting 26 24-inch box trees and shrubs throughout the site. Associated grading includes 341 cubic yards of cut and 257 cubic yards of fill. The project will be served by existing sewer and water providers as indicated by will serve letter from Sanitation District number 2 and 3 and San Jose Water. The project has been determined to be exempt from CEQA under AB 130, which provides a statutory exemption for certain infill housing projects, including builder's remedy projects that are less than 4 acres, located in an urban area, surrounded by existing urban development, not designated as farmland, wetland, and located outside of very high fire hazard severity zone. The subject property is within the urban service area of the city of San Jose and does not have a county general plan designation. County general plan policy states that urban development should occur within incorporated cities and be served by city-level infrastructure and services. And under County Ordinance Code, properties within urban service area are generally expected to be annexed if they are contiguous to the city, separated only by a roadway, or located within 300 feet of the city boundary. The subject property doesn't meet any of the annexation criteria, and as such, the project application was not required to be circulated to the City of San Jose for annexation consideration. However, the applicant submitted a completed general plan conformance and annexation statement from the City of San Jose, in which the city waived annexation of the subject property. As such, the county has a land use jurisdiction over the project site and must render a decision on the project application. The property is zone R1. The table that you can see on this slide evaluates the proposed project's compliance with R1 zoning standards. The R1 zoning district is consistent with the City of San Jose general plan designation of residential neighborhood, as they both allow for low-density residential developments. The proposed development doesn't meet the zoning requirements for minimum front, rear, and side setback and minimum lot area required for a subdivision. However, it meets the maximum height of 35 feet and 2 stories and minimum parking spaces required for residential development by providing 2 covered parking spaces per dwelling unit. The application qualifies for builder's remedy known as SB 330 due to a vested pre-application filed while the county did not have a compliant housing element. Under SB 330, the county's ability to apply standard development regulations such as density, setbacks, height, and parking is significantly limited. The project can only be denied on one of 5 bases under the law, including if it would have a specific adverse impact on public health and safety, and there is no feasible method to mitigate or avoid the impact without rendering the project unaffordable to low-income households. The Roads and Airports Department, Land Development Engineering, Department of Environmental Health, and Fire Marshal Office reviewed the proposed project with respect to all applicable regulations relating to public health, safety, and environmental effect of the proposed development and determined that the project, as conditioned, will not result in any specific adverse impact on public health or safety. Potential public health and safety issues related to this project include fire safety and access, stormwater and flooding. As currently proposed, portion of the access road and fire truck turnaround do not meet the minimum interior turning radius requirements. Fire Marshal Office staff conditioned the project to meet the county fire code, which requires access road to have a minimum interior turning radius of 30 feet and exterior turning radius of 50 feet. And to address the potential issue regarding stormwater and flooding, LD staff conditioned the project to treat runoff with low-impact development treatment measures. Additionally, as the applicant is proposing a new drainage outfall into Babb Creek, but has not demonstrated evidence of permission to discharge into the Valley Water easement, LD staff has conditioned the project to require the applicant to obtain permission from Valley Water to discharge runoff to their easement. And should Valley Water not approve a new outfall into North Babb Creek, the applicant would be required to revise the project's storm drainage design. Compliance with these conditions of approval may slightly change the yard size and number of parking spaces, but is not anticipated to impact the proposed size or number of dwelling units. As such, the potential public health and safety issues can be mitigated through conditions of approval. County staff reviewed the findings required to deny an SB 330 project and determined that none of those findings can be made. First, the preliminary application for this project was submitted before the California Department of Housing and Community Development certified the county's 6-cycle housing element. Second, staff has not identified any specific adverse impact that cannot be mitigated through conditions of approval. Third, the project would not conflict with any state or federal law. Fourth, The project site is not zoned for agriculture or resource preservation, and adequate water and wastewater facilities are available to serve the project. And lastly, as mentioned earlier, the project was vested before the county adopted a compliant 6-cycle housing element. Therefore, none of the required findings for denial can be made, and denial of the project would not be supported under the state law. Based on the analysis presented, staff recommends that the Planning Commission take the following action: accept determination of CEQA exemption and approve the concurrent land use application consisting of a major subdivision and grading approval, including one deed restricted low-income unit subject to the amended recommended condition of approval, which removes condition number 52, requiring the new lot line to be surveyed and monumented by a licensed land surveyor or registered civil engineer, as it is already covered under condition number 15. This concludes my presentation. Staff is available, as well as Principal Planner Samuel Gutierrez, for any question commissioners may have. Thank you.
Thank you so much for that informative presentation. Are there any questions from the commissioners before we open the public comment? No? Okay. We're going to open the public hearing. And if the applicant is here, Mr. Anderson, would you like to speak with us? We'll give you 10 minutes. Thank you.
Madam Chair and members of the Planning Commission, my name is Kurt Anderson. I'm principal of Anderson Architects. Before I give you my abbreviated presentation, I just want to tell you I think the staff did a fantastic job on this report. I reviewed it at length, went through the conditions of approval, and they did a really good job. It was so clear and concise. We're working on several builder remedy in other communities, and this is probably the best staff report I've seen on builder's remedy, so I thought you did a great job. So, as I said, we reviewed the report, we reviewed the conditions of approval. We think everything looks great, and we'd just like to respectfully request an approval. If you have any questions, I'm glad to answer, but that's all I have to say.
Do we have any questions from the commission for the applicant? Commissioner Rouser?
Yeah, I was just saying, you answered my question. I was going to ask you if you were happy with all the conditions that were being recommended, and you said yes, so thank you for answering my question in advance.
It was really, really good report, and appreciation to the staff. Thank you.
Commissioner Rouser has a question for you.
I don't know if this may be for staff or maybe for you, but I did notice there's properties, all these properties are very, very long properties and very narrow. And one of the questions that I had was if the property adjacent to that, if they wanted to provide similar type of housing, can they use that same street, or would that overload it in any way? Is that something that would encourage
It's a
future
very
housing?
good question. It'd be great to only have one driveway, additional housing. That would have to be something worked out with the owner and HOAs that have to be worked out. From a design standpoint, from an architect standpoint, that'd be great. That'd because we reduce the amount of impervious coverage on the site, so we have more green space. In the future, if that came along, I'm sure that we could definitely consider that.
Okay, I was just wondering, is that a public street? Is it dedicated then, or is that still
It's going to be a
considered?
dedicated street.
Right, okay. All right.
Okay?
And just for the record, I did drive by, and I did notice that there were varying qualities of houses in the area, and I think this particular one would be a very good improvement in the neighborhood. I'll leave it at that.
Thank you, we appreciate that.
Commissioner Belska?
Yeah, sorry, I just wanted to clarify. So the road is going to be dedicated as a public right-of-way,
Correct.
which suggests perhaps it could be
And
utilized.
that relates to some of the conditions. We have to build in certain radiuses and all that, so that's all covered under the conditions. Okay?
Yeah, thank you.
Do we have any public comment?
Allowing time for Zoom to populate, we do have one hand raised so far.
We'll take 2 minutes for any speakers.
Seems to be holding at one. We'll move forward with James Gutierrez. Two now. Is that okay with you, Chair? All right. James Gutierrez, you're a speaker. Seems your mic's already unmuted. The timer will begin when you start speaking.
Sounds good. Thank you, everybody. James Gutierrez, if you can hear me.
Yes.
I do live in the neighborhood directly across the street, so as previously stated, Mark, I thank you for coming through. I'm always here if you want to stop and chat. I appreciate the architects for going down this improvement in the area. My question specifically focuses on what infrastructure, are we going to improve any of the infrastructure that's on Meadow Lane? Because typically during the winter, we see a lot of runoff. We have flooding on the streets. Typically that area, there's a lot of backflow of water that runs into that area. We've had numerous times where pipes break and flood those properties, but I just wanted to ask what infrastructure, whether it's sidewalks, lighting, we don't have a lot of lighting in this area. What is the city going to do to improve this, or the designer or the builder? And that was my biggest question.
Our next speaker is Drea Moore. Drea, please accept the unmute, and the timer will begin when you start speaking.
Hi, this is Drea Moore. I'm actually the owner of the house that's next door, and I noticed that it's taking part of our driveway, and that wasn't something that was discussed with us, and that's for the fire turnaround. So I just wanted to understand when we would have that conversation.
Those are all of our requests to speak.
Thank you. Staff, do you have any additional comments to make?
I think for the first question, we could defer to Roads and Airports about the infrastructure improvements along the county-maintained road on Meadow. And then we could provide some response regarding the neighboring property.
Okay, thank you.
Sure, Tom Esch, Roads and Airports. Conditions were actually set for the property's frontage, which included specifically in front of the property itself. The conditions did not necessarily extend through all the adjacent roads, through the adjacent properties as it progresses north or south of Meadow Lane. When we do look at improvements, a key thing that we did comment on was a concern about the adjacent driveway and how some of the improvements may actually impact some of the existing adjacent driveways, including roadway drainage patterns. In this case here, I'll defer to the planning department regarding what the purpose of this review is, but there is another process. It's during the development application review and encroachment permit review that we actually get into all the details.
Thank you. Any additional comments from staff before we hear from the applicant?
Yes, so referring to the question from the neighbor, as mentioned earlier, we conditioned the project to modify the approach. That was conditioned through the County Fire Marshal's office because the approach currently doesn't meet the turning radius requirement. So that would need to shift, and that would be done during the building permit process to adjust that entry turning radius. So that would be presumably an entry that would be more involved coming onto the project site versus taking the turn off-site. So that's where that would be involved.
Thank you. Mr. Anderson, would you like more time before we close the public hearing?
Thank you, staff. Again, like Roads and Traffic says, we'll work with all the details as we go through the construction permitting process. And as far as the neighbor's driveway, we'll get that, we'll sit down, work that out with her, make sure there's not going to be an impact on their driveway.
Great.
We'll clarify that also during the construction sequencing.
Thank you very much.
Okay,
Are there
thank
any
you.
questions from the commissioners right now? Okay, thank you so much.
Thank you.
Do I need a motion to close the public hearing? Or Okay, so I'm going to go ahead and close the public hearing and bring the discussion back to the commissioners. Do we have any comments or recommendations?
I have a couple of hypothetical, I need to be recognized, I guess.
Oh, yeah. Commissioner Levy, yes.
I have a couple of hypothetical questions. And one is concerning whether, if they use SB 1123 instead of SB 330, would they be able to do the same thing as they currently can with SB 330?
Does someone on the staff know?
Through the chair, if they wanted to use that law, they have to reduce the size of the proposed units.
With SB 1123?
1120, yes.
Because you can
20.
put 10 units on a
So,
parcel.
They still can
By
have
right.
10 units, but the size of each unit needs to be reduced. So right now, what they are proposing is more than 1,700, but the AB 1123 limit the size of each unit to be 1,700.
I believe that's 1,600 on average. It's a smaller
It is much
average
smaller than
amount.
Smaller, okay.
Yeah. So there'd be some adjustments that would be required under SB
All right,
1123.
and the density bonus doesn't increase that because it doesn't increase the size or number of units, it just increases the height, it just allows them to reduce setbacks, increase height.
Yeah, it's a bit more nuanced than that for the 1123.
Okay.
Because feasibly, depending on how many units you're proposing, you can propose a larger unit, but the average between all of the units proposed cannot exceed the state mandated threshold for an average size. I believe
Okay, yeah.
it's 1,600 square feet.
Right, thank you. Because, yeah, I'd really like to learn a little more about it, how 1123 impacts everything. It's such an important law now in land use. The second question, another hypothetical, is if this was annexed into the city of San Jose, would we still get the RENA numbers?
Could you repeat the question?
The question is, if this was annexed into the city of San Jose, post, the approval of the housing element, who would be able to take credit for the RENA numbers?
Well, technically, this is Nicole Collins, Deputy County Counsel. RENA credit is awarded at the time of issuance of a building permit. So the default is the jurisdiction that issues the building permit gets the credit. However, there is a statutory process by which when a parcel is annexed, a jurisdiction, the county could work with the annexing city to arrange for a transfer of credits. But it wouldn't necessarily be the equivalent number of the approved units in the project the county approved.
Good. Great. Thank you very much. Thanks for helping me learn a little more about planning.
Any other comments from the commissioners? And any need to disclose any ex parte communication from the commissioners or site visits besides Chair Rouser?
I've been demoted. I'm just a commissioner.
That's just your name in my head. Yes, Commissioner Levy,
I'll make a motion if it's time.
please.
Accept the termination of CEQA exemption pursuant Public Resources Code Section 21080.66, which is AB 130, and then approval of concurrent land use application consisting of a major subdivision and grading approval, including one deed restricted moderate income unit subject to the recommended conditions of approval. And I would also like to say the staff did a fantastic job on the conditioning of this. I was reading through the conditions and I thought, yeah, you really hit it out of the park there. Good job. So.
There's a motion. Is there a second?
Second.
There's a motion and a
If
second.
I may,
Yes.
to clarify, Commissioner Levy, we did recommend the removal of condition 52 because it was a redundant condition.
All right, so amended.
The seconder accepts?
Accept.
Okay. Is there any discussion on the motion? The clerk would take roll on the motion now. Thank you.
Commissioner Rouser,
I approve.
Commissioner Levy,
Aye.
Vice Chairperson Hederly,
Yes.
Commissioner Belska,
Yes.
and Chairperson Cohen.
Yes.
That passes.
Thank you, everybody.
If I could, for one moment. Anyone who is dissatisfied with this decision by the Planning Commission may appeal the decision to the Board of Supervisors within 15 calendar days by filing the appropriate documents and fees. More information about appeals can be found on the Planning Department's website and in the county's zoning ordinance. You may contact the planner assigned to this project with any questions regarding how to file an appeal.
Thank you very much. We're going to move on to agenda item 7. This is a public hearing to consider an appeal of the October 17th, 2025 decision by the Department of Planning and Development to deem incomplete a concurrent land use application for the 1125 East Main Avenue Housing Development Project, consisting of a major subdivision and grading approval for 187 units of housing, 157 single-family residences, and 30 sorry, I can't see with my glasses, 30 low-income restricted units across 2 existing parcels totaling 26.65 acres. The applicant is Bertram Burns. Staff, do you have a report?
Chairperson Cohen, members of the commission. My name is Principal Planner Robert Salisbury, and I'm filling in for Senior Planner Laura Tran, who is regrettably under the weather today. And I do have a brief presentation for you. So as you noted, the project before you is an appeal of the incompleteness determination for the 1125 East Main Avenue project in unincorporated Morgan Hill, county file number PLN 25-093-SB330. The project is located at the corner of Main Avenue and Conduit Road, has a zoning of A-20AC-SR, which is exclusive agriculture, 20-acre minimum lot size with a scenic road combining district. It has a general plan designation of agriculture medium scale, and surrounding land uses include vacant land and an industrial complex to the north, single-family residences to the south, east, and west. The project is, as noted by the chair, it's an SB 330 housing project consisting of a major subdivision and grading approval for 187 housing units, proposed on a parcel, 2 parcels that collectively total 26.65 acres in size. The project also includes other improvements, including interior driveways and stormwater basins. And as you can see on the slide that I'm projecting, this is the proposed site plan that shows all the locations of the proposed lots and the residences on those proposed lots. Just to go over the timeline briefly, the pre-application for this project was submitted December 9th, 2024, at a time that the county did not have a certified housing element, meaning this is a vested builder's remedy project. On May 30th, 2025, the applicant submitted their formal application. 30 days later, June 30th, 2025, the county issued the first incomplete letter for the project. On September 17th, the applicant resubmitted. The county deemed that second submittal incomplete. And then on October 28th, 2025, the applicant filed the appeal that is before you today. So in the June 30th, 2025 incomplete letter issued by the department, the letter included 37 incomplete items, including several from the planning division, land development engineering, environmental health, fire marshal's office, and roads and airports. With their subsequent resubmittal, they did resolve several of those issues, but 17 incomplete items remained, including 1 from land development engineering, 6 from environmental health, 2 from fire marshal's office, and 7 from roads and airports. So in the appeal filed, the applicant asserted that the county could not require submittal of a will serve letter. That was one of the most significant issues raised in the incomplete letter. In this project, they are proposing to connect to the City of Morgan Hill sewer system and water system, but they did not provide a letter, a will-serve letter from Morgan Hill, wherein Morgan Hill agrees to serve the project. So as of right now, there is no water supply or sewer system proposed for the project. And so the applicant asserted that the county cannot require the will-serve letter because they're not information from the applicant and that they constitute code compliance, not application completeness. And they also asserted that the will-serve letters for this project were unlawfully withheld by a third-party government agency. So staff's response to that is, again, the applicant is proposing connect to the City of Morgan Hill, and there needs to be an indication from that service provider that the service is available. And the applicant does have the opportunity to satisfy the requirement in other ways. They could propose an on-site wastewater treatment system and also an on-site water system, neither of which the applicant has proposed on their plans. And if you recall, when I showed the plans, no such systems were identified on the plans. So the next grounds for the appeal is that the applicant asserts that the incomplete items identified in the October 17th, 2025 incomplete letter are either complete or are minor and constitute approval conditions and therefore do not need to be provided at this time. And staff's response to that is that pursuant to the Permit Streamlining Act, an applicant must provide all of the items on the applicable application checklists, and the 16 incomplete items identified in the October 17th, 2025 letter are all and were all identified on the relevant checklist, which is the county's SB 330 Housing Crisis Planning Submittal Checklist, and these items have not been provided by the applicant. As a result, the department recommends that the Planning Commission deny the appeal and uphold the Department of Planning and Development's determination that the land use application for the 1125 East Main Avenue Housing Development Project is incomplete. And with that, I am happy to answer any questions that the Planning Commission may have. Thank you.
Thank you for that informative report. Are there any questions from the commissioners before we open the public hearing? Commissioner Rouser?
Yeah, thank you. Just on the process, I know in the past when there was an incomplete, there were time limits involved, but now with the court case, what happens to those time limits? What are the options of the applicant? If this appeal is denied, do they have time to resubmit, or how does that process work?
Principal Planner Samuel Gutierrez, there of course has since been a Santa Clara County Superior Court decision on the term of the 90 days, so that's already been settled. And the applicant after this would have 90 days to resubmit their application.
Any other questions? Commissioner Belska?
Yeah, sorry, when you say after this, after the commissioner decision, that's when the 90-day
Correct, after the decision of the appeal.
Okay, and that's
Because you're
when,
determining whether or not it's complete or incomplete.
okay, and then
Yes.
that kicks off the 90-day clock. Okay, my question is, what has been happening since October 2025? That was 10 months ago.
Sure. Deputy County Counsel Nicole Collins. So the county was able to enter into tolling agreements with some of the applicants who had been deemed incomplete more than one time at the time that the 90-day issue was not yet clarified by the court, which essentially paused processing of certain applications with the agreement of the applicant and the department in order to give time for the court to resolve the issue. So since the expiration of that tolling agreement, the project is now once again resumed processing, and this appeal is being heard.
Commissioner Levy?
Yeah, just a little clarification on the 90-day rule. is it a single 90-day review, or do they continue to get 90 days review on an ongoing basis, 1, 2, 3, 4 times?
Yeah, the courts have, sorry, this is Principal Planner Robert Salisbury. The courts have determined that applicants have essentially an unlimited 90-day periods. Each time an application is deemed complete, they have 90 days to resubmit, and there is no limit to the number of times a project can be resubmitted.
I'm going to go ahead and open the public comment and see if the applicant is present and wishes to speak. Yes, please join us. Would you like to speak? Yes, please join us. Thank you so much. You have 10 minutes.
Hold on just one sec. I want to set up because I have some slides, and I went through this earlier to make sure that I'm able to share. So hopefully it allows the sharing. Let's see. Okay, I put the sharing on. Let's see. It says you are screen sharing. We actually ran this earlier. Is it actually sharing yet? Yeah. You just have to. Oh, I see. Got it. Okay. Oh, perfect. Okay, great. Terrific. Thank you. Adam Burns for applicant. Nothing is decided today about whether this project is approved. It's about the checklist and completeness and whether the Permit Streamlining Act allows the county to ask for something that depends on a discretionary third-party approval, and we pay for all of it. So let's look at what the Permit Streamlining Act actually tells the county a checklist is. The county compiles a list of, in the statute's words, the information that will be required from any applicant. Information from the applicant. A year ago, in August of 2025, our outside counsel, Brian, who is actually here, submitted a detailed legal analysis of why the language does not permit what the county is doing here. It went in with the resubmittal and is attached to the staff report. Hold that thought. I want you to look at what Santa Clara County requires for water and sewer. You can look at it here. Look at what the county actually requires of a project proposing its own private systems. A septic plan, soil profiles, a percolation test, for a new water system, a feasibility study. What it doesn't require is the final regional board or state board approval. That comes later and nobody disputes it. Now look at our row for public connections. Our project sits directly on water and sewage mains that run up and down East Main Avenue and on Condit 2. For the public system, the checklist doesn't ask an applicant for any information at all. Instead, it asks for something another agency decides, a will serve letter. We gave them the information anyway, the lateral connections for the water and sewer, and the capacity studies for both. And here is what page 5 of the staff report says about that. We are asking you to deem this complete, quote, without any information demonstrating there are feasible drinking waste and wastewater services for the project. Feasible. It did not say approved. So let me go to the next slide. I'm trying to figure out how to do it here. Perfect. That is package page 802. It went into our brief. A 12-inch water main on Condit Road and 8-inch sewer main on East Main, and the 4 points where we connect. That is the information the report says doesn't exist. And note the word again, feasible. What we submitted matches what the county accepts for every private system applicant. The demand, capacity, and the means of connection. Here, the means is lateral to mains already at our frontage. We believe we have the legal right to connect, and we will carry that risk ourselves. And in fact, we have a writ action against the city of Morgan Hill in January on that very issue. We are not asking you to waive any part of the county's process. We're asking that it be followed. The staff report then says that we should have proposed a private system or a new public system instead. On page 4, if a will serve letter cannot be provided, the applicant will need to propose a new public water system if one cannot be identified nearby. So the applicant requirement remains a will serve letter from the city. Well, one can be identified nearby. It is the city's, and it's the main at our frontage. So the alternative does not reach us, and what remains is a letter that the city won't give us. The report also calls a will serve letter a standard requirement at the land use entitlement stage. Note the word. We agree entitlement is approval. Tonight is about completeness. And these private systems have their own third-party approvals. Notice the county's own ordinances. Section B1162 requires connection where a sanitary sewer is available within 300 feet. Section B1165 allows an on-site system only for a building that cannot be connected. Ours can. And a new public water system means Health and Safety Code Section 116527. And that report must contain a discussion of the feasibility of each of the adjacent community water systems, annexing, connecting, or otherwise supplying domestic water to this site. That system is the city of Morgan Hill. Every rule in this area sends this project to the city mains. The only rule pointing the other way is a completeness rule that makes the path the only path that we can't take. Every road the county points to ends at an agency that isn't us. The Housing Accountability Act already tells the county what to do if the project lacks adequate water or wastewater. Under Section 65589.5D4, it permits the county to disapprove it at the approval stage on written findings supported by the record. The legislature addressed this exact question by name and put it at the end of the process. And this isn't how the Subdivision Act treats outside agencies. For every tentative map, the county notifies the school district within 5 days after the application is determined complete and considers what the district says before acting on the map. Complete first, outside agency second. The MAP Act uses the same construction for Caltrans, for the Department of Water Resources, and for water suppliers. The county has taken the one agency in this case and moved it to the front. Now to the rest of the list. 9 of the 16 items are not the will serve letters. 2 of them depend on no one but us. The easement is a line on our plan, and the staff report says so, either an easement or a label, and both are ours to draw. The hydrant data has to be less than a year old under the county's own items, which is why it was taken. It's taken at construction drawings. 7 of the 9 roads and airport comments came back literally word for word from June. They didn't look at it because we gave a lot of comments word for word back. Staff now says our responses didn't answer these things: city boundaries, future width lines, and cross sections. Our engineer's sworn declarations answers each of them by plain seat, and no one has disputed a paragraph of that declaration. Section 65943B requires the written determination to state what checklist information is still missing, and not until tonight's report did anyone identify what roads and airport thought was missing. And importantly, Government Code Section 65589.5H5, the local agency shall bear the burden of proof in establishing the application is not complete. The county has the burden of proof here. Now that brings us back to the legal letter from August of 2025, written over a year ago by Brian O'Neill, our outside counsel, who is here. There were 2 occasions to answer it. First, the October 17th determination, which never mentions the letter or a single argument in it, and never so much as acknowledged even receiving it. Second, this staff recommendation, which is the document you were given to read here. It acknowledges receipt in one sentence and then engages with absolutely nothing in it. The report mentions the act only for the points nobody disputes at page 4, that the county may compile a checklist, and at page 5, that an applicant must supply the items on them. That second one assumes the answer to the only question in this appeal, which is whether the item may lawfully be on the checklist at all. On that question, the report offers no authority, not one case, in 9 pages on an appeal with no factual dispute to an 8-page document with numerous statutory and case sites. So before you vote, I'd ask the commission to put one question to County Council. Does the county contend that the Permit Streamlining Act permits conditioning completeness on a document that another agency has discretion to withhold, and that no act of the applicant can compel? And if it does, where in this record is that analysis so that you're able to weigh it? Whichever way that comes out, weigh what each choice costs. One choice ends the dispute tonight and lets us move forward into environmental review, with us carrying the entire risk of obtaining the will serve letters. And if this project ever gets built, it gets built on public connections, which is what everybody should want. The other leaves standing a rule that blocks every builder remedy application except one proposing its own wells and its own septic systems, which the county code allows only when a property cannot connect. And it still decides nothing about this project. So we would ask that you reverse, you would deem the application complete as of September 17th, 2025, and let the staff begin review on this project. Thank you.
Thank you. Do the commissioners have any questions of Mr. Burns? Commissioner Rouser?
Can you just go into a little more detail on the items that you say roads and airports did not?
Yeah, so on the roads and airport, there were actually I think 9. There were originally 9 or 10 items. They took 3 of them off, and then the ones that they kept on, literally, it was word for word, absolutely word for word what they said back in June, even though our engineer gave extensive comments back. And he has that in the declaration that you have access to. Unfortunately, our engineer was traveling. He's in Korea right now, and he wasn't able to make it.
So you're asserting that those answers from the engineer satisfy
Correct.
those requests?
And it is the obligation of the county to actually engage in a new answer. You can't just literally word for word, and it was exactly word for word what they said in June.
Okay.
That is what our engineer said, and I actually looked at it. I mean, I'm not an engineer, but that's what the engineer said.
And then another question. If you were unsuccessful at the lawsuit with the city of Morgan Hill,
right?
What is your position as far as this application then?
Yeah, so
being a feasible application.
Yeah, so then we would literally have to go back, and we would have to try and figure out whether there was any way of doing it with private water sewage. We think it'd be very challenging. We think we're going to win the lawsuit. And, you know, look, if you think about it from a policy point of view, because we're all worried about environmental issues and everything else, and everybody, I think, in the county would say, if you're sitting on a main, literally on a main, we only need a lateral. If you're sitting on a main water and sewage line, it's a lot more sanitary. It's a much better way to actually have it go through the city systems. The way the county is doing this, literally, you can look at every other builder remedy application that I know of in the county. They all have been forced to actually do private water sewage. And then what happens is, and I've seen this, the county and the cities are going to the State Water Resources Board and the regional board and saying, this is horrible, you can't do this. So what are you going to do? You got to pick your poison somewhere, right? And so what we're trying to do is what we believe is going to be the best for the county, for the city, and for everybody else.
Got it. Thank you.
Thank you.
Commissioner Hederle?
Yeah, excuse me, can you come back for another question? I just have a quick question for you.
Sure. And if you need to, to get into the really detailed stuff, we have our outside counsel here, Brian O'Neill, too.
Great. I'm just looking for a little more clarity about what your position is as to the items that were identified as incomplete. Is it your position that you have provided all of the items on the checklist other than the will call letters?
Yeah, so, you know, the engineer's the one that actually knows the details of this better. He's the one that gave the declaration that I actually submitted. In his view, he said these are not completeness issues. The sort of two things that the two other things that I went over are things that, and I've actually looked through a lot of the other ones that have gotten through as being deemed complete that have way more issues than what we have. I mean, seriously, if you go and look at this, and I would encourage you to, these are items that are not reasons for us to have been deemed incomplete. And the biggest one were the 7 issues, which came back literally word for word.
So your position is not that you've provided everything they've asked for, but rather you disagree with their authority to ask for them?
No. We actually think that from from the point of the checklist, we did everything that was required of the checklist. When it ends up getting into the items like of the airport stuff and the other stuff, that was the opinion of our engineer who under oath testified to it. You know, again, I am not an engineer, so I can't get into the details of like what's normal and what's not, but we actually believe we had one of those pre-meetings where we went through everything, and he believed that we absolutely did everything. But I think the major issue here that we're looking at is the will serve letter, because I think the will serve letter is really the main reason that we ended up getting turned down. As I said, we're trying to do everything we can on it. We sued the city of Morgan Hill. We got through the demur stage. We're actually going to be going to trial in January. Who knows how long this will take. And we are taking literally all of the risk. If we don't get that will serve letter, we're back to square one. Fine, you can turn us down then and say, well then, okay, you better go and get some private system or some other way. That's fine. I'm not saying that this project is a finished project. What I'm saying is let us start the EIR process like all of the private systems got to do. If you think about it, every one of those private systems, none of them have regional and state water board approval, and yet all of them are moving forward. Why? I mean, what you're doing is counterintuitive. You're encouraging people to go a route that is the less sanitary of the routes. I don't know.
Thank you.
Okay, thank you.
Commissioner Belska?
Yeah, I actually would like to go into detail in into these roads and airports items, and it is unfortunate that the applicant's engineer isn't here, but maybe roads and airports can assist in this, and I don't know if now is the time to do that, or if we should do that after public comment.
I'll ask the clerk, do we have speakers on this item?
We do have one hand raised on Zoom at this time, and none in the room.
Why don't we take public comment and then we can revisit our outstanding questions? Yeah, great.
2 minutes, Chair?
Yes.
Alrighty. Alice Kaufman, you are first and last speaker. Please accept the unmute, and the timer will begin when you start speaking.
Thank you. Good evening, Chair and Commissioners. This is Alice Kaufman, Policy and Advocacy Director for Green Foothills. And we're asking you to please uphold the incompleteness of determination. It just doesn't make sense to deem the application complete without having answered this extremely basic question of how the project will obtain water and sewer service. Now, the main difference between an incomplete application and a complete application for all practical purposes is that once the application is complete, the project moves into the environmental review stage. But this project is not ready for environmental review because it is missing information the county will need in order to complete the EIR. The county is not going to be able to evaluate the impacts of the project on local utilities, which is required by CEQA, without the information from the city on things like capacity and any infrastructure that might be needed were they to provide water and sewer to the project. And there's also the information that's missing having to do with roadways, fire hydrant flow data, The EIR is going to have to analyze transportation impacts, wildfire impacts. It's simply not going to be possible for the county to do an adequate EIR without this information, and that is exactly why the information is needed in order to have a project, an application complete and ready to go into the EIR stage. So, and then finally, I want to say the complaint that the county has treated other projects differently is not correct. The difference that's pointed out between the other projects having proposed on-site water and wastewater systems, not saying those are certain to either be feasible or environmentally acceptable, but that is precisely what CEQA is for, is to analyze those environmental impacts. And here, there just isn't the information that is going to be needed to do an EIR on what the applicant's proposing, because that information is with the City of Morgan Hill, and they have said they are not providing service, therefore they're not going to have this information there to provide. Thanks.
Thank you. Are there any other public speakers?
We do not have any further requests to speak.
Does the staff have any additional comments?
I'll just say that the speaker there summarized it fairly well. There's simply not sufficient information about the project to allow us to do environmental review. And so, and there's also, of course, reasons for all the information on the checklist related to review, not just against CEQA, but for health and safety, provision of services. There's a variety of reasons why the information on those checklists is on the checklist. And we have, other projects have provided what has been requested here. And it was deemed incomplete in the county's view for very reasonable and legitimate reasons.
Thank you. Thank you, Rob. Commissioner Belska or staff? Yes.
Sorry, if I can add, Principal Planner Samuel Gutierrez, to note about the differences between the other projects that had private water systems. They did provide preliminary technical reports, which do provide the information, at least at a basic level, for us to complete CEQA analysis, where we don't have any such information in this project right now, because we don't have any of the numbers and figures which are being requested in several of the incomplete items related to Department of Environmental Health and fire service as well, because they asked for fire flow rates, hydrant data, and of course that goes into utilities and emergency services analysis, which also get done in CEQA.
Thank you. Commissioner Belska?
Yeah, so I don't want to waste time by going through the entire list of items. So I want to take one possibly simple one as an example. Let's take item 11, which basically says identify a curvilinear dedication to public right-of-way, including minimum 50-foot radius at the intersection on the plans. It's difficult for me to look at the plans and say, is this there, is this not? So if I could ask for Roads and Airports to bring up the plans and show whether or not, or staff to bring up the plans, and then show.
If we could have a moment to load them up.
Okay.
Sure.
Through the chair, I can actually start answering as part of the question while they're preparing that.
Thank you.
We were informed in a letter that the airport and airport repeated the exact same 9 comments from the first incomplete letter without acknowledging the responses and revisions provided. In that case there, we do actually do that. And in the letter, it said the county's failure to review these responses does not justify continuing incompleteness. So I do have a response for all of this. Roads and Airports reviews all resubmittals and provides comments that reflect items missing or needing clarification on the plans. Plan reviews for resubmittals are treated as an entirely new review, with comments specific to that plan being reviewed. Roads and Airports reads the response letter provided and will consider what is being said. However, we do not comment on the letter. We comment on the plans that we review. And therefore, going on with it, we're not actually going to comment on the letter or refute anything on the letter. We're starting over. We're looking at your set of plans. In the review of the last plans resubmitted for the applicant, the responses provided, the letter that they did provide to us, dated September 17, 2025, did not answer or confirm the requested information. Plans were reviewed, information is still missing, and therefore the comment would have to be repeated. They're not responding to it. And I have some examples, and I'll bring up that one example as it's very specific. Every single one of those comments, I can tell you exactly why we had those comments there. Plans were reviewed, information still missing. So essentially, the applicant would not receive the exact same comments. If they provided the missing information, I would gladly not provide that comment. The October 7th, 2025 incomplete letter from the Department of Planning and Development included the contact information for roads and airports. At no time was I ever contacted about these questions. There's a reason why we have our phone number is there, our contact information is there. We would love to help out the applicant and if they have any questions about it. So we're fully available. We would have provided any information necessary or helped them point to sources of information, as is commonly done with other planning applicants who do contact us and they want to understand something, and we'll work with them as if they came to our plan counter and we would talk with them. And that did not occur in this place. You had a comment for comment number 11. I believe if planning can confirm this, but East Main Avenue has a feature width line, 46-foot half street width, identified currently in a dedication. The applicant's response from the applicant was, in their letter, was additional right-of-way dedication to address the comment was made and is shown on sheet C 3.0. So I reviewed sheet 3.0. I also review sheets before and after, just in case they got the numbering all wrong. I'm very thorough. We're trying to be very consistent on this. I don't want to repeat the comment if I don't have to. But the area to dedicate was not identified. The radius to dedicate was incorrect, and it was also not identified for dedication. The legend does not even identify the future width line, and it's not even called out on sheet 3.0. Again, I looked at all the sheets. It's not in there. Therefore, I determined the information requested was still missing. I repeated the comment then. So that's the basis for number 11. Is your question, if there's a question about future width line, I can also talk about that as well. As county ordinance is a requirement, it does call out that the board does require on plans and on maps are required to have the future width line or the official plan line. And it is a checklist item.
Yeah, that's
available for any
fine.
other questions. Tom Esch with Roads and Airports.
Okay, yeah, thank you. No, basically, I wanted to, if we could, bring up in the hearing and show the plans and show where the missing information is, because the applicant is contesting that they addressed that comment. County is saying the comment was not addressed, right? If we bring up the plans, look at the plans, that should answer the question. Is it addressed or is it not?
Through the chair, I have the plan sheet C 3.0 displayed, and so if
and I'm just using 11 as an example because I don't necessarily want to exhaustively go through every single one and waste our time, but if we can demonstrate on one of them, kind of
I'm not sure.
who's right, who's wrong, right? Thank you.
I'm not sure.
So if you can just walk us through this, maybe with the pointer, and say, where should there be information that isn't being shown and that the applicant said has been added?
I cannot show you the future width line because it's actually not on there. It would be a designation as FWL, or it would actually be specifically called out. In this case here, I would also even look at the legend and determine if on the legend does it have that information. If they don't call it out, I don't even see it in the legend. Therefore, I can't call out where the future width line is because it's not there.
Since we still have public hearing open, can we ask the applicant?
The applicant has 5 minutes remaining if you'd like to share any more comments with us, or if our commissioners have any questions for you.
First of all, I think the most important issue here, because even if we had to do a re-application, is this issue of the will serve letters. And
I'm sorry, I'm specifically asking you to address the missing item.
With respect to the fire, he references a letter, but the actual, the letter that we were talking about was the legal letter on the other issues. I have the declaration of our engineer, who actually said that in his experience as an engineer, and again, I'm at a disadvantage here because I'm not an engineer, but what he said is, look, he has never seen a situation where he literally gave extensive comments back after the June application, and he word for word, literally word for word. So nothing was addressed in what he was doing to actually address the first set of comments.
Okay, but
June.
there's nothing addressed in the submitted file. The information that was asked for is missing from this drawing.
Well, my understanding, I mean, I don't have the full application of everything that he actually sent. My understanding was he sent extensive comments, and unfortunately, he isn't able to be here because he is in Korea. But he actually does have a specific to these issues. He has a sworn declaration on these issues. So I would advise you to just take time and look at what his sworn declaration says. I unfortunately am not an engineer, so I can actually speak to the will serve because that's more on the legal side of stuff. On that stuff, that's what our engineer said. He has never seen a situation.
Yeah, thank you. It sounds like the applicant is unable to address my question. And it's
I mean,
that they're engineers.
unfortunately, those are engineering questions. All I can say is he made extensive comments back on his second submittal, and he got exactly the same comments to what he said on the second submittal. Exactly the same comments. So, which doesn't really show that they did any kind of review of it. That is what he swears to in the declaration. I can't say more than that.
Okay, thank you.
Okay.
Are there any other questions from the commissioners before I close the public hearing? Okay, I'm going to go ahead and close the public hearing and bring the discussion back to the commissioners. Commissioner Rouser?
Yeah, I'll go ahead and state for the record, I did drive by the place on my way to this meeting. It happens to be on my way. Because this is a completeness, I didn't really have any observations relevant to the actual thing because we were just dealing with the completeness issue. Just a couple of general comments. The approach of having some of these developments utilize the sewer provided by the city and the water provided by the city, I think is awesome. And I wish, if possible, all of these SB 330 projects could utilize it. But that's not the way the state has set it up for us. And I was part of the group that did revise the septic laws about well over a decade ago, and there are a lot of ways now that the waste can be treated on site, and if you have enough money, it can be actually done in a very, very, very small space. And we've had some of them come before us, and they're actually pretty high tech, and they seem to be good options. And so I'm torn on this one because I think, like I said, I wish they could just connect to the sewer there. I happen to have the sewer go right in front of my house, but I'm in the rural area and I cannot connect to it, so that I understand the frustration. But in this case, it would be nice to just be able to put these under conditions of approval and say you have to have a certified water source in some way, but I do understand that the analysis would be very incomplete, and you'd literally have to go through the process twice if ultimately the courts did not grant them the ability to connect to the public water source. So at this point, it looks to me like there are cases, there are items in here that it is incomplete, and they are beyond the consistency argument. And so I'm just going to put that as my comments to the commission and the public.
Thank you. Commissioner Belska?
Yeah, I mean, the thing that, troubles me is that on the one hand, the applicant is saying we have this attestation from the civil engineer that he did everything, but we were just shown the plans and those items aren't there. And so from what I can see and the information I'm gathering here, those items are in fact still missing, and therefore the comments being included again seems legitimate. And again, we didn't go through all of the items. If the commission feels we can, but to me, I'm satisfied with the one example. Chosen at random, right, from that list, the information was missing. And so it does seem like the items are not there.
Thank you. Is there any more discussion or action from the commissioners? Commissioner Levy?
Yeah, I concur. Our job is to make sure, and we only have one job, is that the list is complete, and I think we were shown that it's not. But the question about the will call letter is a very compelling one, because there was some logic in what the applicant was saying about if they, assuming they could get the water and they provided the technical details associated with the water they were getting, PSI, whatever else there is in there, which I'm not sure they provide that level of detail. And so I'm not sure their application would be complete in that regards either. But, if they're basing their application on, we are going to have this, and this is what we are going to provide, then that is very similar to the other usage of offsite, of using water that's local, that's well, sewer that's done locally. I don't think they provide those details as far as this is what's going to be provided, and I'm not sure they can do that without the will call letter. That's really something that staff needs to discuss, but it does say very clearly in the checklist, will call letters on multiple occasions. So the checklist does say that, and we can't change the checklist. That's not within our preview, so obviously it's not complete. But I did want to just bring it up that the applicant did have a compelling argument, assuming that they provided all the technical details associated with what that will call letter would say. But if, I agree with the other two commissioners here that I don't think we have a choice but to deny the appeal, so.
Any other commissioners?
And I assume you mean the will serve letter.
Yeah, deny the appeal.
Sorry, you were calling it the will call letter. Will serve. Will, yeah.
Okay.
Yeah.
I got tickets will call last week, so.
No, and I do agree, right? If that was the only item that was actually missing, I would have a lot more difficulty with this because like you said, there are some compelling arguments there as to, is that a completeness item or is that a compliance item? And, we've had issues of water as a, actually even a compliance item versus a condition of approval item come up, right? So it tends to, it's a complicated issue. And if it was the only one, I think I would have a much harder time making a determination. But that said, I don't really understand why the applicant would want us to deem complete an application that basically says we have no water, because then as soon as that gets to the compliance stage, well, you have an application that has no water, denied, right? I mean, right? So it seems to me like it's in the applicant's benefit to actually get proof of water such that when they go into that next phase, their project actually has a chance.
Thank you. Commissioner Belska and then Commissioner Hederly. Yes.
Yeah, and that point about the will serve letter, I do think I see that distinction a little bit differently. I feel like it is a very uncertain situation right now whether the utilities will serve this project or not. And in fact, it's under litigation at this moment. And if in fact they're not able to achieve it, I hear you saying we bear all the risk, and yes, you bear a lot of risk in that case, but you would have to theoretically redesign the entire project. We will have spent more and more staff time throughout the process, and I think just as a good governance matter, it's not good practice to approve to move forward with such a yawning gap in a critical detail. So I don't see that will serve letter as a minor issue, but I see it as a major issue.
Thank you. Would anyone like to make a motion?
I'll make a motion.
Commissioner Hasabi?
I'll make a motion to deny the appeal and uphold the planning department and determination that application for the 1125 East Main Avenue housing development project is incomplete.
There's a motion. Is there a second?
I'll second.
A second by Commissioner Hederly. Is there any discussion on the motion? Do we need to restate the motion for the clerk, or can we vote on it?
We're good to vote.
Okay.
Commissioner Rouser,
I approve.
Commissioner Hasabi,
Yes.
Commissioner Levy,
Aye.
Vice Chairperson Hederly,
Yes.
Commissioner Belska,
Yes.
and Chairperson Cohen.
Yes.
Motion carries.
Thank you, everybody. We're going to move on to item 8, which is to receive a report from the Department of Planning and Development relating to code enforcement program, general operations, and structure.
Good evening, Commissioners. Jacqueline Anciano, Director of Planning and Development for the County of Santa Clara. We're before you today for you to receive a report on the what we're calling code enforcement, but we're looking to change, the name to code compliance. Daryl Revere is our program manager for the Code Enforcement Program. This was one of the items that was on the Planning Commission work plan, and the Commission had asked for us to come before the Commission, speak to the Code Enforcement Program, and answer questions the Commission may have. And so I present to you Daryl Revere. Thank you.
Had problems with this before when I was here. Thank you, Director Anciano. I appreciate the introduction. If you give me just a moment to get a document up here so we can be fully prepared. All right. Wonderful. Okay, good evening, Chair Cohen, fellow commissioners, and staff. My name is Daryl Revere. I am the Code Enforcement Program Manager for the great County of Santa Clara, as Director Anciano already said. I am here tonight for an informational discussion with you all about the county's Code Enforcement Program. You have before you a report on the current general operations and basic structure of the Code Enforcement Program, and tonight is your opportunity to ask questions and discuss the program and maybe code enforcement in general to a certain degree. Before we begin there, I would like to share a little bit with you about my background and what I bring to the County of Santa Clara before we dive into the report. I bring with me 26 years of code enforcement experience and 30 years plus of public service experience. I began my public service career with the great County of Santa Clara as a seasonal park ranger in the 1990s. And now I'm fortunate to have the opportunity to finish my career here, where I began in 1992. I served 8 years on the board of directors for the California Association of Code Enforcement Officers, also known as CASIO, including 2 years as the association president. KCO is the largest state association that represents code enforcement officers in the United States. I was honored to lead over 2,000 code enforcement professionals and promote the code enforcement profession, which I believe helped prepare me to lead the county's code enforcement team and program. If it pleases the commission, we can turn to the report and begin our discussion.
Hey, Nathan, he's trying to, can you give him, how can he hook in?
Oh, yeah. Yeah. Okay.
Okay, hold on. Pardon us, just one moment. Oh, so you have to.
You have to log in. Okay, sorry for the delay there, folks. Okay, so I really wasn't planning on reading through this whole report and bore you all completely to death tonight with it. I'm hoping that we've had some sort of review prior to it. So I really want to just kind of have maybe a discussion about this. So if anyone had any questions, if any commissioners had questions, we can go through or scroll to that part of the report. I can do this any way that the board wishes, excuse me, the commission wishes. We can make this short and sweet, or we can dive into this. So I really leave it in your hands to what's best for the commission.
Are there any questions right now for Daryl, or should we take a few minutes to hear from him? Commissioner Hederle? Yeah. Why don't you give us a brief overview, and then we'll ask questions. It's an important program, and we'd like the updates.
Sure. Okay, thank you. Okay, so let me start by telling you a little bit about code enforcement in general. So code enforcement is not about exerting authority. It's not about enforcing compliance on folks who, without education and without understanding of what the expectations are. What it is about community education and promoting the health and safety and vibrant communities within our county. Oftentimes, code enforcement officers are looked upon as law enforcement officers, and as we may be part of that family, we are not. That's not our primary objective. Our primary objective is to make sure that the residents of Santa Clara County are living in healthy, safe conditions, and that we're promoting vibrant and high quality of life in our communities. Our program specifically is a smaller program as compared to some of the other ones in California, but we work diligently to make sure that we respond quickly and timely to all of our complaints, and that we fairly apply the law, the local laws and state laws that we enforce to everybody in the county of Santa Clara, to all of our residents. Our program has its challenges, as does any other code enforcement program out there, and I don't think there is one in the entire country that can say that everything works perfectly all the time and is smooth and perfect. But we do have a very strong team that is dedicated to making sure that our residents are treated fairly, respectfully, with compassion, and that we are there for them when they need us. Code enforcement is not about being punitive. It's about helping folks achieve their goals and also make sure that they are living in, again, safe, healthy homes and communities. In the report before you, we have several different aspects of the code enforcement program, from the tools, the various tools that we use, our approach to education, which is probably our number one tool that we use when we interact with the general public. That is one of our number one goals, is to make sure folks understand what the local laws are and how they apply to them and maybe to their situation. Some enforcement, of course, is involved, but we try to keep that to a minimum. We feel education and working with folks is the best way to achieve our ultimate goal, and it's the ultimate goal of code enforcement profession, is voluntary compliance. We want to work with folks to make sure that they get to the end game of correcting whatever situation it is that we were called there to investigate. So we have a variety of tools that we use for that, which we can get into a little bit later, but I want to tell you a little bit more about our program in specific. We have 6 code enforcement officers for the County of Santa Clara, ranging anywhere from just a couple of years of experience to over 25 years of experience. It does not include my experience as well. And I do also serve as a part-time code enforcement officer as well as my managerial duties. So I'm still out there in the field with the other code enforcement officers, keeping in touch with what they're going through every single day and keeping in touch, more importantly, with the community as well and their needs. I've met several of you at other meetings, and we've had discussions as private citizens. It's nice to meet everybody else now, too, and I encourage you at any moment after the meeting and in the future, if you ever have a concern or a question that maybe we don't cover tonight or something else that comes up, please feel free to contact me directly. I'll make sure you have all my contact information before we leave tonight. I would love to hear from you.
Thank you so much, Daryl. Are there any questions from the commission? We'll start from our far left, Commissioner Hasabi, and we'll just go this way.
Thank you, Chairperson. I appreciate, thank you for the report, and I appreciate your focus on compliance instead of enforcement. I was hoping you can share a little bit more about what tools you have used or plan to use in terms of public engagement and education.
If I may, let me just back up a little bit just to give, we'll answer your question, Commissioner, but let me just back up just to give a little more overview if I can. So the code compliance program also, I just want to clarify, just give you some understanding of the structure. The code enforcement program comes under our building official, Michael Alvarez. He's the deputy director and building official for the County of Santa Clara. And the code enforcement program comes under our what we call development services. And as Daryl stated, there are 6 code enforcement officers, including Mr. Revere, who also is a part-time code enforcement officer. Some of our outreach is we have various meetings. We attend the San Martin Planning Advisory Committee meeting, the San Martin Neighborhood Association meeting at request. We are currently kind of on a hiatus, but we have what we call the Roundtable Committee, where we're educating our frequent users of our permit system on the code enforcement program. But Daryl's working to expand the public outreach and education tool. We haven't perfected that yet, but when we wanted to advance that was when we changed our code enforcement program over from code enforcement to code compliance. So we're looking to do that maybe in 2027, late 2027, 2028. We are currently working on our permit process improvement, and one of the number one modules for this change has been the code enforcement program. I want to let you know what tools we actually use when we're addressing code enforcement or code compliance issues. So I'm going to use code compliance. First of all, we are complaint driven. So it is not where we're out looking for violations, but if there's an officer of the county that sees a violation when they're out in the field, whether it's a building inspector or code enforcement officer, they will come back in, and before we start any type of investigation, if they see something that looks questionable, they will come in and go through our files and review the files. Maybe there's 2 houses and we didn't know that there was a permit. We won't open a code enforcement case, and when I say a case, it's an investigation. It's not a violation, it's an investigation. We won't open that case unless a complaint has come in or unless we can't validate some issue we see out in the field. So we open a code enforcement case, or what we call a violation case, and that's when an investigation is taking place. If the complaint is substantiated, then we may use a number of tools. We may use a warning letter, we may use a notice of violation, and so we try, as Mr. Revere said, to get compliance before we're going into enforcement. And I want to acknowledge that we have one of the lead county counsel, Michael Rossi, who can speak to when we get to the legal side of it, if the commission so desires. But we prioritize our cases, and one of the number one priorities is health and safety. So we deal quite a bit with substandard housing. And so when we work in the substandard housing realm, we first try to work with the property owner. We want to work with that property owner. We enlist if there's an issue with environmental health, if there's an issue with the building department. He has at his disposal our building official. And so we try to work with applicants to get compliance. So I spoke to a warning letter, notice of violation. If we can't get compliance, we'll use something we call a compliance agreement. A compliance agreement is a voluntary tool that we will offer an applicant. What it does is, or a property owner, what it does is it helps us work with the property owner to negotiate a timing for when they will come into compliance. Sometimes when we're working with them, they may ask for extended periods of time. And so that's a negotiated tool. That's one of the tools we may use. We try to offer the compliance agreement as a voluntary opportunity before we get into the legal process of compliance. We don't want to go that route because that gets very punitive, and so we try to not go to that level. What else was the part of your question? I want to make sure I answer it.
No, you addressed your question. I was just around what type of tools you use for engaging these issues.
Yes,
thank you.
And another important component of all of what Director Anciano just said, and I've mentioned it a couple times already because it is very important, is the education side. We want to make sure that folks that we're dealing with out there understand the why, not just the what. I know in my own personal life, if I understand why I'm being asked to do something, I'm a little bit more amenable to actually doing it. But a lot of folks these days, the first question is, why do I have to do this? And usually our response is because it's for your health and safety. Because that is the majority of what we deal with is health and safety complaints. There are nuisance complaints. There are things that are annoyances, you may want to call them. But the chief complaint we get are health and safety related, like Director Anciano says, substandard housing, wastewater or solid waste, human waste issues, servicing wastewater, things that directly impact the general public or endanger the general well-being of the community as well. But we want to make sure that people understand why the rules or the regulations that we are presenting them with, what the intent is. And when folks understand the intent, they're more likely to understand, to comply. We're able to gain that voluntary compliance. So a big part of what we do is explaining and communicating. That's probably our number one officer tool out there, is our ability to teach folks what the reason is behind the law and how it impacts them, which then usually brings us to the voluntary compliance.
Thank you so much. Commissioner Belska?
Yeah, thank you. So reading through the report, I noticed that each individual has a caseload of between 150 and 500 active cases. That's like that's like simultaneous, how is that even humanly possible to work through?
I have to ask myself that question as well. And that is accurate. Actually, those numbers are maybe a little actually under what we actually face in our agency. It is difficult, to say the least, to keep up with 150, let alone 500 cases. We are going through an update of our complaint tracking system to help our officers better track and be more efficient about it, to give them some extra tools to help them keep track of 150, 200, 500. 500 is unusual. That's not the norm, just so you know, but it is a reality. It's probably somewhere really, if the one solid number, you're probably around 250 to 300 cases, which is still a lot of cases to have to keep track of. That's a lot of cats to herd, let's just say. And it is not easy, but our team has tools. We provide them with tools to do that, and the updating of our complaint tracking system is going to benefit them greatly and be able to hopefully even improve our ability to not only manage those cases, but to respond even in a more timely manner to those new complaints as they're coming in, because they come in every single day. We average about 600, right around 600 cases a year from fiscal year 2021 to 2025, 26. Some years it was higher, some years it was lower. During the COVID years, complaints skyrocketed. And then post-COVID and pre-COVID, they were a little more manageable, shall we say. But we do also have quite a load of cases from previous years that we are still trying to catch up on as well. So there's quite a hill to climb, but our officers are dedicated to doing that, and we are trying to improve our systems as well as implement new tools to help them do that.
On the topic of tools, are you considering any AI tools to help manage that workload?
AI is an emerging technology for code enforcement right now. It hasn't quite hit its stride, I think, in our profession. It's always something we're willing to look at anything that is that will help us, of course, with lots of research and lots of looking into it. But we haven't done much on that level yet that I'm aware of. I know there are some endeavors into AI for different parts and different departments of the county, but we have not had that discussion yet in the Department of Planning and Development for the code enforcement group yet.
Right.
But it is possible.
Okay, thank you.
Commissioner Levy?
Yes, I was also concerned with those numbers that were the pretty large numbers for an individual caseload. If you're getting 600 a year and there's 6 people, that'd be about 100 a year. So these would last multiple years, 2, 3, 4 years. Is there an issue with getting these closed on time? If there was a way to resolve these issues a little more quickly, would the workload be less? Because just based on the raw numbers, these things are staying open for years.
Yeah, and that's accurate. Some cases, as I said, we're dealing with a backlog of cases as well, that before we had 6 officers, we were 2 or 3 officers, and that does not allow for a whole lot of case closure when you're seeing 600-700 cases a year.
Can I speak to one item, though?
Sure.
We had embarked on a program where we were working on this backlog, because the backlog, many of these officers inherited. It wasn't created, it was created from years of not resolving. And they actually cleared out, in about a 9-month period, they cleared out about, I'm gonna say about 400 cases, because some of the cases had resolved themselves. Some of them were low-lying cases, graffiti. They were different kinds of complaints.
Mm-hmm.
Please understand, the caseload is large, but they're in various stages.
Right.
So when you see the prioritization in the staff report, they're not all substandard housing. The substandard housing or safety issues, they have to attend to those immediately.
Okay.
That's not an option. So they'll put a towing of a car. Somebody, they may have some complaint about multiple cars on a property. That may go to the side where we have children living in a unit that they can't get in and out of, right? So.
Right. And to speak to the long term of some of these cases that we get involved with are very complex, and they do take years to resolve due to permitting and just the actual enforcement, the investigation side of it. For instance, some of our most complicated and longstanding cases involve grading and land development, and that unfortunately is not usually an open and closed type case, maybe it's such as like a graffiti complaint or something like that. So it's a combination of very complex matters, as well as resource allocation, as well as just the sheer numbers coming in. I've worked for jurisdictions where we've had 10 times the number of officers and 10 times the caseload, and it's no different. So the County of Santa Clara is not an anomaly when it comes to large numbers and small number of people to address them. But a big part of it, Commissioner Levy, is the complexity of some of these, and they do go on for years. And unfortunately, there is a segment of the population that no matter how hard we try, and no matter the tools we give them and the education we give them, they are just not willing to comply.
Yeah, well, that's where I was going to go next,
Yeah,
actually.
let's just put it straight like it is. There is a certain segment of the population that we have a little more difficulty, but we still work hard to try to convince them that the law is the law, and you have to be in compliance with it.
Yeah, well, I appreciate you doing more, compliance rather than enforcement. But there are, based on these numbers and the time frame and so forth, if you had a lot of compliant individuals there, these things would get closed a lot faster. And so, I'd be interested in knowing, out of that 600, how many require enforcement letters, and then how many do you actually move forward with some type of penalty after the fact? When I was a San Jose Planning Commissioner, there was a property where these people, because we were the Code Enforcement Appeals Board as well, there was somebody who chopped down 20 redwood trees. They were, permitted sized, or what's the property term? But they were, large redwood trees, and they cut down 20 of them.
Landmark.
Heritage.
Yeah. Ordinance-sized trees.
There you go.
There's the word, ordinance-sized trees. So we had, 20 ordinance-sized trees cut down. They didn't ask permission or anything else. How would you handle that? I mean, that's the kind of thing where you want to take legal action and penalize them. I mean, there's a penalty size of this as well. And I'd sort of like to hear, based on the numbers you have, how long it takes, where do we come by and say, okay, we need to, have some type of enforcement to prevent other people from doing the same thing as well.
Sure.
So how do you handle that?
Yes, we work closely with our county council. I'm going to ask Michael Rossi to join us at the dais, not the dais, here. I don't know what we call this, but I'm going to ask Michael.
Welcome, council.
Yeah.
It's called a hot seat.
No, because we work closely with our county council when we have egregious violations, and I'll call them egregious violations, where we do impose fines and penalties, but it's a process, and I'll let Michael Rossi speak to that.
And that's why I was asking, if you have those 600, of how many actually get notices of violation, and then how many do you move on to the next step after that?
I'm not sure we can just rattle that number off for you. We can come back with that number, Commissioner Levy, but that's not a number that's where I can just divide it up for you, how many.
Okay, great.
Can you give a percentage?
I can tell you it's significant. I would say the majority, we first of all, every complaint we get, we investigate. Probably north of 90%, we actually visit the site and we actually conduct an inspection. There's a small number of cases or complaints that are handled administratively, where they're referred to another organization or another department, such as the Sheriff's Department, or maybe they're within the incorporated boundaries of the city of San Jose, so we'd refer it to them. That's a very small number. But if we receive, let's use the 600 more. If we have 600 cases in a year, we're visiting darn near every single one of those properties. There are other instances as well through our research in the office before we actually hit the field, where we may find a permit that actually addresses the complaint, and that one will be closed administratively as well. But as far as how many move forward through with a violation letter or notice of violation, again, I can say I can't rattle that number off, but again, significant, the majority of them. Most times when folks report something to us, there's validity to it. We have very few cases where we actually close them as unfounded or no merit, meaning there was no violation there. May have looked like it, but when you actually apply the county ordinance and the state law, there was no actual violation. Even in cases where it was close to it, where it didn't meet the violation threshold, we still talk with folks to let them know you're dangerously close, so they understand not to take that little extra step maybe, or to be careful of what how they're using their land or what they're doing there. But the numbers are significant. Unfortunately, I just can't give you a specific number, but they're definitely north of 75, 80%.
Do you want to speak to, he was wondering about the fines on cases.
I can speak to that too. So.
Do you want to speak
Sure,
to the fines?
sure. As far as the penalties, as you called them, we do everything we can to avoid that. We want to not have to be punitive, as Director Onciano said. That's a tool of last resort for us. However, in certain instances, it's unavoidable. And in some egregious cases, we actually have to go to that step fairly quickly. Something that is a severe danger to or threat to the public health and safety, or it's so egregious that we have to take firm, fast action. We might go to that, we may get to the penalty stage much quicker than something that's a little bit less, more of like a car on the front lawn, for instance. That would be something we would work very, very hard to not ever get to the point where we would have to levy a fine or assess a fine to somebody on that. So it is a tool of last resort, is what we call it. But there are consequences, and we do enforce those consequences. I like to call them consequences more than fines and penalties. It's just a little bit easier way to put it. And people are a little less, become a little less, not afraid, but they take that a little bit more. It's just a kinder, gentler way of saying that, I guess. But we do use those, and we do when we have to. Our compliance agreements are one way that there's a consequence to those, and Michael Rossi knows those inside and out, as he was one of the key developers of that program, which he may end up talking about here. But there are consequences, and we do use those, but only as a tool of last resort.
I would remark that county council can become. Can you hear? I'm sorry. Yes. Can you hear me? County council can become involved in a code enforcement case in any number of ways. At the outset of a case, we're available to the community protection team, which is a team within the county council's office that assists code enforcement and other enforcement departments within the county, provides advice at the outset to determine what the best path for enforcement would be for a more serious case. If we have a case, especially those that involve not only planning and development, but the environmental health branch or roads and airports, or another enforcing department within the county, county council helps to coordinate those actions and determine what the best step forward for those is. Those will not always involve filing of a civil action. We hope to resolve those at a lower level, including, as Mr. Revier just mentioned, compliance agreements. Compliance agreements are a tool that we utilize to get more complicated cases into compliance. Those are cases where there are multiple violations, where the responsible party needs additional time to abate violations, and those agreements require that a property owner or other responsible party admit to the violations, commit to a timeline on which to abate, and in exchange for their promise to do so, will face reduced administrative fines and a promise not to civilly enforce. However, if they are unable to comply with the terms of a compliance agreement and are unable to obtain an extension, and we try to give property owners and responsible parties every opportunity to abate, then they are stipulating to judgment entered in the county's favor. It's a compliance agreement is a binding contract. In a vast minority of cases, that would be at the top of the prioritization criteria that you see on the screen. County council will initiate a civil action on the part of, on behalf of the county to enforce the county's ordinance code. The other way the county council becomes involved is when a party disputes a notice of violation. Notice of violation has safeguards because it imposes fines, a responsible party is able to challenge whether or not the violations exist and the amounts of the fines. The way that the ordinance code is set up, they first must seek a departmental level review, and in that review, they are able to provide evidence that they believe shows that they did not commit a violation. They're also able to assert why they do not believe that the proposed administrative fines are at the correct level. From there, if the director upholds the notice of violation, then the next step for a responsible party is to go to the county office of the county hearing officer, and that's an administrative proceeding, a quasi-judicial proceeding, where again they can present evidence to a neutral third party, an attorney with at least 5 years of practice in California who is not affiliated in any way with the county. They would decide the appeal of the director's decision regarding the notice of violation. And from there, if, again, the county doesn't prevail, or the county, if the county prevails in most cases, then they have the ability to bring the action before Superior Court, in which case county council would obviously become involved as the legal representative for the county.
Thank you.
Thank you.
Commissioner Rouser?
Yeah, thank you for the report, and I appreciate the philosophy that you guys have put on this, and I know you've had times where both the budget and the amount of personnel have been inadequate, and it's tough to do what you're trying to do with the resources you have, but I do appreciate your approach of education first. And what I would like to ask specifically, and I realize I cannot bring up individual cases, there is a use permit that we approved on, I want to say it's 40 East San Martin Ave. It's between Depot and the railroad tracks, and they have it's like a truck depot, essentially. And again, I'm not here to discuss that, but what I would like to do is, I know the Planning Commission does have the ability to request to revoke use permits. So I'd like to know about that. And I'd like to know, is there a way we can agendize and publicly notice a meeting to discuss the violations and the attempt to get them consistent with the use permit that we did approve?
I'll defer to either Council Rossi or Director Anciano for that.
I'll take it.
procedure. Yeah.
Let me
Jack.
just preface while you're gearing up for that. San Martin, downtown, I think ranks as one of the ugliest communities. They used to have two big trees there, green, and as part of the beautification project, they cut those down. And they hope to put some crepe myrtles and other ornamental things on it, but ultimately, when you look in that area, you see the truck depot was supposed to be all hidden by ornamental trees and everything, and it's not. The intersection and everything, many of the buildings have put San Martin guideline type paintings and everything on it, so it's not rural at all anymore. And so that's just one element of frustration that we have in driving through our community. We had the students come and do this great design thing with all these great ideas, and here we are with the ugliest downtown possibly in the state. I don't know. This is one component of it, and it's very frustrating. So that's why I'm bringing it up. I'd like for this to come to SIMPAC and to us if possible.
Is it just the depot, Jacqueline Anciano, Director of Planning and Development? Are you requesting the depot come before relative to the use permit and compliance with the conditions? Or are you speaking to us taking a look at compliance of the whole downtown area of San Martin?
Right now, I'm speaking specifically of the use permit, because I know there was a compliance agreement and fines have been, so you guys are well down the process of looking at it. This is not new to you guys.
Yeah.
But this has been going on 8, 9 years, something like that. And it's very frustrating for the people, the community of San Martin. And I would be negligent if I didn't bring up the design. And I know we're working on the general plan, but San Martin does want to keep moving forward on the downtown specific plan. So thank you.
Thank you. We will take a look at that. The depot.
Yeah, you flagged both the things I wanted to talk about, not San Martin, but conditional use permits. And I think it would be really helpful for us to understand more about what happens once such a permit is approved, if there are complaints that it's not being complied with, how is that resolved? Is there a role for the Planning Commission in situations like that? And which leads to the other area of questioning for me, which is the public transparency. How do you handle complainants? Is there kind of a feedback loop? If all of your investigations are driven by complaints, that means that there are people like folks in San Martin who are frustrated that they've complained about something and they don't see the solution happening. What is your approach to addressing that? And
I'll let Daryl speak to this, but I want to say we are not good at this. We do not have a system in place that returns a call back to people. They have the ability through our Excella to see the case number, the date the case was opened, the case number, and then the status on the case. They can do that. But we had to pull down their access to much of the information as far as sometimes they can see when an investigation happened, but they are not getting information back as to the case has been resolved. There's 4 investigations. 16 investigations have taken place. It's now going to court. We don't have the staffing to do that with the caseload that we currently have, but we are doing, one of the commissioners, it might have been Commissioner Belska, I'm not sure, asked about how we're using AI. So one of the items we're working on, we're updating our system. I don't know if many of you have seen, we have gone before the board and Hewlett with a presentation on the permit process improvement. Part of that program is having an automated system that will bounce back a response to an applicant on a referral, on a submittal, on a complaint. We're not going to be able to give them full information because some of it is confidential. We have to be careful what we say. But we are working on automating how we can respond back to the public when they've made a complaint. Because right now, they make a complaint, they see a case has been opened, they see the status, but that's it. So we know that's not satisfying, and we know it's not transparent. So we're trying to use technology to figure out a way to give them some information. And then we'll have to work closely with council as to what that information will be.
yeah, I think that was the second step of the question is what kind of limitations are there about what can be shared as a case is resolving?
I couldn't quite catch that second part.
Sorry, I wondered if there are limitations on what can be shared as a case is evolving and approaching resolution. Surely there are confidentiality issues, but not about everything. So.
Yeah, we're very careful about, for an open and active investigation, we're very careful about what we can and can't release. Similar to a more like a criminal case, the sheriff's department might be investigating. They also have obviously limitations. So do we as code enforcement. We protect our complainant information with every ounce of our being to make sure that we don't discourage folks from calling us out of fear of retaliation. A lot of folks think that we tell people who called or that they called. Because let's face it, we have neighbors complaining about neighbors, and we sometimes even have family members complaining about family members. And one of the first questions we always get is, who called you? And say, well, we can't tell you that, but we verified there's a violation, so now the County of Santa Clara is your reporting party or your complaining party. We assume that role at that point. But we hold that very closely, because if people are thinking that we're going to be divulging that they are the ones that called, they're not going to call us, because unfortunately our society, there's a certain segment that would retaliate in very serious ways, not just maybe having a harsh word for them across the fence, but something a little bit more serious. So folks are very careful about that. And in today's society, especially in Santa Clara County, folks are just in fear in general. So when they call us to help them, we want to assure them that their identities are going to be protected as much as we can under the law. In my 26 years of code enforcement and tens of cases I've been in court, I've never had a superior court judge force the organization I would be working for at that point to release that information. I mean, that's the only way we would actually release it, unless counsel, correct me if I'm wrong, but I'm pretty sure that's under the only circumstance we would release reporting party's identity, because we assume that role. So as far as keeping our residents in the loop, I've implemented a rule or a policy, internal policy, that my officers are to contact the reporting parties within a certain amount of time. We're still working on what time frame really works best, is feasible. And then also making sure they get a phone call back at the end, at least, saying that we've resolved the issue, so they know, so they don't have to rely on another form. I think that's just part of customer service, and that's another big part of what we're about, is customer service. And we do have to do a better job in doing that, and we realize that, and we're trying to take steps to make sure that we're doing that. But as Director Anciano said, the demand on the staff is significant now, and being able to update them on a regular basis, as much as we would love to be able to do that, it's just not feasible at this time. But we're trying to find ways to improve it for sure.
Thank you. Commissioner Rouser?
Yeah, I just wanted to bring up again, it's my understanding that we don't actually have an ordinance that talks about blight, but I was just wondering if you could just give us what is the current status when it comes to either graffiti or blight or whatever. What are the standards that you guys are looking to that we as property owners are being held to?
Well, we do actually have a graffiti ordinance that speaks specifically to graffiti, and we do have a property maintenance, if I remember right. Michael Rossi may be able to elaborate a little bit more on that. So we do have ordinances that do address blight specifically. There's lots of different types of blight, and we have some specific ordinances that deal with the different aspects, and there's a general ordinance, but then there's also very specific ordinances for excessive outdoor storage of materials, graffiti, unkempt or dilapidated structures and properties. It's all in there. It's not just packaged really nicely under one ordinance. It would be great if it was. It'd make our lives a little bit easier as well. And it'd be easier for the public to be able to actually go and take a look and understand the rules. You know, our county ordinance book is very thick. There's no way we can expect them to understand it, but if we can make it a little bit easier, maybe through an AI search or something like that to find that, maybe that's something we should look into in the future. As far as the AI question, that may be one way we can help incorporate that in our daily investigations and our daily work as well.
But that's not what you asked. You asked what the standard is for blight?
I was told blight isn't actually in the code or ordinance or whatever, but there are ones that address the concept of it.
Right. Yes.
And so I'm just...
Yeah, blight is an umbrella term.
Right.
For a lot of different issues out there, public nuisances, property nuisances, those are all umbrella terms.
And I like your answer. Ultimately, can we get something a little more that we can use as an education and something that would help define that in a way that people can say, okay, those are the standards I need to meet. And
You're
I
speaking
think
to-
that would be helpful.
Are you speaking, Commissioner, through the chair, about like a brochure, something to educate the public
Sure.
relative to what the code is?
But
That's-
having a nice, concise code behind that brochure would be
Yes.
very helpful.
Okay, thank you. We will add that to the list.
Thank you. Commissioner Belska?
Yes, thank you. I actually, I think one of the questions that Vice Chair Hederly asked, and also I think was raised by no longer Chair Rouser, Commissioner Rouser, it was the question about the ability to revoke a use permit if the use conditions are being violated. Is that something that this commission can do? How would that work?
I can speak to that if
Okay,
that would be
please.
helpful.
Yeah. Go ahead.
Yeah, so as you heard, most of the code enforcement work is not, right, overseen directly by the commission. We have a separate Office of the County Hearing Officer, but you are correct. There is a provision in the zoning ordinance. It's number 5.20.210, and it relates to revocation or modification of use permits, basically discretionary approvals that were granted by the commission. The ordinance sets forth certain findings that would be required to be made based on, receiving evidence, evaluating the evidence that would allow potentially modifying conditions of approval, revoking a use permit, or basically not, if you can't make the findings, then the use permit stays as is. So it's not directly involved in, we're issuing a notice of violation. It's just a hearing on the use permit and the conditions of the permit.
Commissioner Belska and then Commissioner Hederly?
Yeah, sorry, just to follow up, is that something that the Code Compliance Office could initiate with the Planning Commission?
The zoning ordinance allows it to happen, a hearing to be held on the Planning Commission's own motion or at the direction of the Planning Director or Board of Supervisors.
So to answer your question, the question from Commissioner, through the chair, pardon me, the question from Commissioner Rouser about that particular bringing it forward, it can either come forward as he's already asked, it can come forward initiated from the director or from the board. So he's just asked for us to look into it. Once we look into it, we may bring it before the commission, but we have to look into it first.
Do you have any follow-up questions? Thank you. This was a very informative and interesting discussion, and thank you so much, Daryl, just for all of your hard work. And I think that Santa Clara County usually sets the bar in most things that we do, and so it doesn't surprise me that we're leading with compassion, but also being really smart about how, we're engaging in these conversations. I would also be curious or to ask that in the future, I think there's a unique overlap between issues around worker wage theft, misclassification, some of the work that we've been doing with county council around health and safety violations. And I wanted to know if the Office of Labor Standards and Enforcement was part of the community protection team.
The Community Protection Team, in addition to the work we've discussed tonight, has a workers' rights initiative. A few years ago, the State Labor Commissioner began a program where local jurisdictions, including counties, can receive grants to do labor code enforcement and worker protection work, and we do that. We have a team of attorneys that focuses on those types of cases with OLSE.
Thank you. I would just say, similar to Commissioner Rouser's interest in holding a standard, I would also say that if there are bad actors that continue to be bad actors, and we can hold them accountable, I think that we should do that. I think there's a different grouping of people that are not just regular folks trying to figure out how to get something done. And so the distinction between those two, I think, is important. And the more that we can lean in on whether it's the public health department or the planning department, I think the better that we'll be as a community. So thank you for the work. We don't need a motion to accept the report, but I want to just make sure there aren't any other outstanding questions. Yeah, everyone okay? Anything else from the staff?
Just thanks for the opportunity to be here. Very much appreciate it. Make sure you get one of my cards before we leave, and don't be afraid to reach out.
Thank you very much.
Thank you.
Okay, we're
Excuse me,
gonna-
through the chair.
Yes.
We do have 2 hands raised in Zoom for public comment.
Thank you so much. Okay, we'll take them 2 minutes each.
Okay, sounds good. Our first speaker is Diane Dean. Please accept the unmute. Your timer will begin when you start speaking.
Am I unmuted?
Yes.
Can you hear me?
Yes.
Okay. I want to thank Commissioner Levi and Commissioner Hartley and Chair Rouser for their comments. I don't think they got honest answers from the 3 sitting at the table. I'm just going to give off 4 questions that I have. What is the significance of changing from code enforcement to compliance? Have any of you looked up in the dictionary to see what enforcement means and what compliance means? Compliance is you're holding their hand. Is that your intent? Because when Daryl spoke to the San Martin Neighborhood Association, he was very honest and open, and people had a lot of confidence in him. Now I see that he's changed his tune. When the public calls code enforcement, they expect to see results. It sounds like what the code enforcement compliance wants to do is hold everybody's hand. By the time a community member calls code enforcement, they're expecting a resolution. So I don't understand what your mission is. Your mission is very simple. You do your complaint prioritization criteria, and that's it. And then my last question is, if you're really paying attention to code enforcement, there's a person sitting on the San Martin SIMPAC Advisory Committee who has 12 to 13 violations on their property. It has not been addressed, and that person has been cleared as a commissioner on SIMPAC. That is not right. I'm finished.
Our next speaker is Sharon Luna. Please accept the unmute, and the timer will begin when you start speaking.
Good afternoon, Commissioners. Thank you for the report on the code enforcement. I understand code enforcement officers have a difficult job. They deal with frustrated residents, difficult property owners, potential legal and sometimes intimidation and other engagements. My comments are not directed at the officers. They are directed whether the systems that are being proposed in this report are working for the public. The report says code enforcement serves 94,000 residents across 627 square miles of unincorporated county. Not 94,000 residents are all filing complaints. The more meaningful number of this report is that code enforcement receives an average of 600 new complaints per year. This is less than 1 complaint annually every 150 residents. Some residents file more than 1 complaint. So that raises the obvious question, how many unresolved code enforcement cases does the county have today, and how old are they? I know for myself, I've been into plan commission's concerns. I agree as far as working with the complainant and the person who is the step.
I'm sorry, Sharon, you're cutting out at this time. I've paused your time.
Oh, Okay, my internet is going down.
You sound better now if you'd like to complete your 25 seconds.
Okay, thank you. But it's important to know how many are open and how long they've been open. And I think that's good for the public to know. Residents understand that government cannot resolve every complaint overnight. But the residents will cross report answers. They deserve what is going to be happening. Thank you.
Thank you. That concludes our request to speak.
Thank you. I believe that's all we have on item 8, and we can move on with the rest of the agenda. Thank you, staff, very much. We appreciate it. Agenda item 9 is to receive a report from the chairperson. I just want to say 2 brief things. One, just thank you to Commissioner Rouser, the clerk's office, the planning department, and the county counsel's office for helping orient me to make sure that I'm effective in this role. And also, I was able to present at the Hewlett Committee about our work plan, and they received it very well. So great job in making sure that we're doing relevant work for the Board of Supervisors. They were very positive about it. Are there any reports from the commissioners? Commissioner Rouser.
I have one. I, at the end of last month, attended the Gilroy Rodeo and had a great time, which of course was under a conditional use permit that we approved. And I'd like to just give you some statistics on it. This year, over the 3 days, they had 16,500 spectators, 328 rodeo contestants, 854 junior rodeo entries. In the special kids rodeo, they had over 25 families. They had 450 community volunteers that put in 2,500 hours. 34 nonprofits benefited to the tune of over $125,000 went to these community organizations. So, and most importantly, there was 0 major safety incidents at the rodeo. So I just want to keep that fresh because we approved it, and they have done a great job having a great event, and the security was very tight, but it was also it was visible but not overbearing. So my hat's off to those that put on the rodeo. So that's my report.
Any other commissioners? Commissioner Levy?
Yeah, that was nice to hear, since we did approve that conditional use permit a while ago. A question for the clerk here, and that is, have we arranged rooms for the convention, for the conference?
Forgive me, I am covering for Cynthia, so my knowledge is quite limited. From what I know, for the APA conference, a legislative file has been created and has been pushed through to the board for mid-September, and we're waiting for approval there.
Yeah,
But
I
all
thought
of the
we
information
received-
is compiled.
Oh, I thought we had received approval for that, and I think it's important that we get those rooms, because those rooms that are actually there associated with the conference go very quickly.
I can ask Cynthia to follow up with you as soon as tomorrow.
Okay, that's great. And then the second item, a little more personal, is that not sure I'll be able to make the next meeting. I'm sure hoping I can, but my daughter's getting married 2 days later.
Ah.
So I think I may have family obligations. We'll see what happens.
What time should we be there?
Yeah.
Anybody else? Okay, we'll move on to any reports from County Council.
I don't have anything to report, thank you.
Okay. A report from the Planning Commission Secretary.
Anastasia Aziz, Interim Deputy Director for the Director, Jacqueline Anciano, and no reports at this time. Thank you.
If we move to item 13, announcements and correspondence, there's item A and B on the agenda, and item C, we have received no correspondence. Our next meeting is September 24th at 6 p.m. here in Chambers. It would be appropriate to take a motion to adjourn now.
No motion required.
Oh, no motion required. Okay. Yes. We're done. Thank you, everyone.
Yeah, I'll take them.